Thank you everyone for joining us for another Learning Lunch hosted by formatapproved.com. My name is Brian Johnson. I'm the Senior Director of Online Training and Education at Format Approved, and I'll be your moderator today. Today's Learning Lunch will cover avoiding red flags that might trigger an MU audit. We are joined today by Jim Tate of EMR Advocate, Inc. Jim is one of the top meaningful use audit experts in the country, and he has helped to guide both eligible professionals and hospitals through the audit process. We hope that none of you ever have to go through a meaningful use audit, but in that circumstance, you definitely want Jim in your corner. We have a large audience for this webinar, and I know that there will be many questions. Remember that you can ask questions of our presenter at any time by entering them into the chat area during the presentation. In the second half of our session, we will address as many questions as time allows. If we do run out of time, written answers to the questions will be posted to our website and sent via email link later in the week. Also, our guests often ask us for a copy of the slides. Note that all registered attendees of today's session will receive an email with links to both the slides and the recorded version of this event. Well, Jim, thank you for joining us today.
Brian, it's great to be here, and thanks for the opportunity to discuss this, as time goes by, more and more important a topic, the EHR incentive audits, and then, of course, right behind that, the appeals that might be related to negative determination of an audit.
Yes, there's tremendous interest among people now about the ramping up of the audit process, so let's get right into it. Why don't you review some of the basics of how the meaningful use audits are working?
Sure, I'll be glad to. And this was something that we knew was coming, Brian. When the High-Tech Act was passed back in the early months of 2009, funding the entire EHR incentive program for both Medicare and Medicaid, we knew at some point down the road audits would be taking place. And so it was almost like you could see these coming over the horizon. Last summer, those audits started taking place, and there have been some modifications to those audits as we move forward. And so CMS performs audits on the Medicare and dual provider groups. Dual provider would be typically a hospital that receives, is eligible for both Medicare and Medicaid incentives. So Figliosi and Company in New Jersey, they handle those Medicare and dual provider eligible audits. But the pure Medicaid audits are operated on a state-by-state basis. Since the Medicaid funding and incentives comes out at a state level and the attestations are done at a state level, that's where the audits occur. And so with the dually eligible and the pure Medicare audits, it's an extremely consistent process being done by one group, whereas those Medicaid audits can vary quite a bit from one state to another. Now, of course, one thing that was kind of interesting was the first year of eligibility for a Medicaid provider, they didn't have to achieve meaningful use, just acquire, implement, or upgrade certified technology, and they were able for the incentives. But moving forward after that first year, have to start meeting those meaningful use objectives, and so then there'd really be something there to audit beyond just possession of certified technology and meeting the Medicaid thresholds. So, and then the question beyond that is maybe what changes have taken place in the meaningful use audits over the last year or so. They've been in place for about a year. And last summer, just about a year ago, was the first audits that I was seeing, and they were audits based on 2011 attestations. They were post-payment audits. Providers had received their incentive money, and then sometime later, audits were taking place. In January of this year, January 2013, we started seeing the first prepayment audits. So as soon as someone tested, they would be eligible to be audited before payment even went out. So I've seen quite a few of prepayment as well as post-payment audits already. And on the appeal level, CMS is handling the appeals for the Medicare and dually eligible providers, but the pure Medicaid providers, those appeals are taking place, that process, on a state-by-state basis, so not quite as consistent as to those that are dually eligible or just purely on the Medicare side.
Well, I know we're going to get into the appeals process to the audit here in more detail, but let's look at let's dive deep on all of this. So, how does the auditing work at a more detailed level?
Sure. The actual during attestation, the attestation web-based forms that are either CMS or if it's pure Medicaid would be at a state Medicaid site. Primarily, I imagine most of our listeners are Medicare or dually eligible interested. And the attestation process, filling in those web-based forms, there is an actual process as you fill out that form. It's almost like a wizard, software wizard that leads you from one screen to another. And any inaccurate entries such as selection of quality measures or not filling in all the blanks in certain fields and things like that will immediately flag an error there and tell you that this needs to be fixed. So there are some elements in the actual attestation process that helps detect some of those inaccuracies. One reason we need audits, there's no doubt we need them, is because the attestation process itself right now is based on people telling the truth. These incentives are for the meaningful use of certified technology, but when you attest, you're asked for an identifying number of what the certified technology is, and there's no cross-check or background check on that at all. Just you enter a number, all the other numbers can just be put in. So the potential for fraud is easy. I'm not saying people will do much fraud, but it would be very easy to successfully attest without any real documentation whatsoever. We need that audit process out there to make sure that individuals really are meeting the requirements. No doubt about that. Some of the other detailed aspects of this is that the providers, if they are found ineligible, they must pay back the incentives, and it's at 100%. So if during an audit, the auditors require documentation that is supportive of your attestation submission, if you don't have documentation for every one of those items that allowed you to achieve successful attestation, you'll get a demand letter even if you miss one element for the entire recoupment of the incentive that you've received. And I've recently seen some providers who attested in 2011 and then attested in 2012, late in the year. Actually, at the end of 2012, beginning of 2013, they have an ongoing audit for 2011, and they've been told that their funds for 2012 will not be released until the 2011 audit has been resolved. So there is a lot of confusion on the part of really many vendors, many providers, many hospitals, because back in 2011 when we all first started attesting, or many providers started attesting, there was a big rush to attest because there was a lot of money. Even a very, very small hospital, 20 beds critical access hospital between Medicare and Medicaid, would be eligible for $1.5 million or more in 2011 for a very small hospital. So there was certainly a push. I mean, that's a strong incentive. But there was also not a lot of clarification and guidance about some of the meaningful use requirements. We'll get into details of those later. And so now, 2 years later, being audited, you are expected to have had the knowledge that you needed back in 2011, or if you can't prove that through documentation or give a really good explanation, all that money goes back. And that's a pretty big piece of change to go back, no doubt about that.
So, you know, I know we're going to get into more of these details here in a moment, but we talked a couple of months ago in a learning lunch about the meaningful use audit process, and I've often thought and repeated what you said back then, which is that for in many cases the audits are not going after the low-hanging fruit. They're going on after the fruit that's fallen on the ground and is rotting, because it's cases where the attestation was clearly not done appropriately. And so some of the folks who are getting audited for 2011 just clearly didn't do it the right way, although there were those constraints you were talking about that people didn't really understand the process completely then either.
That is totally true, and I get calls every day, Brian, from providers as well as hospitals who really didn't understand such measures as one of the core measures, security risk analysis. Many vendors don't understand that requirement, and during an audit, when you get that audit letter, it comes by email. They're going to ask you for all your supporting documentation, including that security risk analysis. And if you say, well, my certified EHR was past security certification, that's not security risk analysis.
That is not what they mean by that.
That's right. And I would not be a bit surprised that as far as providers, not hospitals, but eligible professionals, practices, 2, 3, 5, 10 providers maybe, if they were all audited, I know there's just no doubt that at least a third would not have an acceptable security risk analysis, and maybe over half wouldn't. It's just very, very common. It was either a knowledge gap. Well, there's no doubt it was a knowledge gap, and remains a knowledge gap to this day. Hopefully it's getting smaller, but it's still very prevalent. And I've talked to many eligible professionals who still don't understand it, and they attested in 2011 and 2012, and here they are in 2013, and they've never done this. So
we hear the same thing all the time ourselves about people who still haven't done that HIPAA meaningful use risk analysis. But that does bring us into our next slide, so let's talk about some of the common mistakes that people have made during the registration attestation process.
Yeah. You know, the idea of red flags, you know, if you don't have a security risk analysis, that's only really going to come out during an actual audit. But the types of things, the red flags that might generate an audit, well, first of all, there's definitely going to be some random audits out there, no doubt about that. That's going to spin the wheel of fortune, and if it lands on you, you're going to get one of those letters. But also during the attestation process, where you're asked to enter meaningful use numerators and denominators, such things as did you provide patient-specific education materials to your patients? And the denominator is the number of unique patients. The numerator is how many of those you gave patient-specific education, provided those materials to those patients. And so the denominator is unique patients. So there's a number of meaningful use measures in which the denominator is exactly the same, unique patients. So it would be relatively easy to do a database query against somebody's attestation to make sure that certain meaningful use responses have the exact same number in them, because they're all based on, quite a few of them are based on unique patients. Some are unique visits, unique encounters, things like that. So there has to be, some fields must be consistent. If they're not consistent numerically, then something is wrong with those numbers. Now, an interesting thing that I have seen recently is, and it's because of my background working with EHRs that have become certified. I've worked with over 200 vendors through their certification processes. Back in 2011, when they were vendors were doing the certified technology development to incorporate the ability to generate these meaningful use numbers, numerators and denominators that would then be attested to CMS to make someone eligible for the incentives. There was confusion around what made up some of these numerators and denominators. So I have seen some meaningful use dashboard reports in which for patient-specific education, it was over 100%. Well, you don't have to think too long to think, well, that's obviously obvious. That it's not a red flag on the part of the provider. is a red flags being generated by erroneous database queries out of the EHR. Now, CMS has said when that occurs, if a provider relied on erroneous data from a certified system, it's really not their fault. So depending on the audit process and how those things go, I think someone can make a good case that they still met meaningful use, at least on the basis of reports that came out of their system. So I think for 2014 certification, we're seeing much more strict testing of that automate and measure calculation functionality in EHRs, and we're going to get more and more accurate data. So red flags not only part of providers, but also the vendors themselves by the data that they generate for reporting. I think there's some paranoia about that.
Now, what about this capability to exchange key clinical information? How is that tripping people up?
Yeah, that's a great one. That's another one that many providers didn't understand. The government barely understood it. The requirement for 2011 and 2012 was there had to be one test of the ability to exchange of key clinical information. That was a file, a CCD or CCR file, a file that really had information on one patient in it. And so there had to be one test of the ability to exchange that file from your system to another system, another EHR, another certified EHR, maybe across town. It could be a test. Interestingly enough, the test did not have to even be successful. Just had to prove you did a test. And we now know in hindsight, done by generating one of these CCD or CCR files that any of these systems who are certified could do, and emailing that file to another practice, some secure encrypted fashion, email it, and asking them to reply when they received it. That type of documentation would be sufficient to meet this measure. But a lot of people didn't understand what this was all about back in 2011. The government didn't also, in a lot of ways, as I said. And so for 2013, during attestation, for anybody who attests this year, that meaningful use objective has been removed. It's no longer required. So if somebody is being audited for their 2011 or their 2012, and they didn't do that or can't document that they did it, I would certainly have a discussion with your auditor about, well, this isn't required for 2013, and so we didn't do it back then. And is there any ability to more or less get a pass on this one, since even CMS has admitted it was very confusing and has removed it. One reason they're removing it is because we're moving totally to for 2014 secure messaging and patient portals, and so this other ability to exchange patient data, this exchange of key clinical information, is really gone by the wayside.
Well, before we move on, I just want to say that we've already got a number of questions from our audience, and we welcome your questions. We're going to wait until the end, and then we'll present those questions to Jim and get you the answers you're looking for. But let's move on for now. So for our next question, Jim, how can providers get prepared in case they are audited?
Sure. Well, I've been through a number of audits now, and the ones that go the smoothest are the ones that when they receive that email from the auditors saying, greetings, you've been selected for an audit engagement, here's the documentation we want, and to just go to a drawer or a shelf where all that documentation that was used during attestation is in one secure single location. That includes the meaningful use dashboard reports that came out of the EHR, that's security risk analysis, proof of possession of a certified electronic health record, any documentation required from the vendor or out of your system that would document some of the non-percentage based meaningful use measures. One thing early on in the audit process I think was very difficult for the auditors as well as for all the rest of us was that I don't know, we have over 300 complete EHRs out there, maybe more than 400, but at least over 300. And so the way that they document some things really varies a lot from one system to another. So there's had to be flexibility that's been learned on the part of the audit process. I'll give you one example. One of the requirements for meaningful use is the ability for the clinical decision support rule or rules to be enabled for the entire reportable period. Well, to document that, to prove that, some EHRs have an administrative screen. We do a screenshot, and it might have an audit that shows that the system was on the entire time. Other systems are hardwired, so they cannot be cut off, but there's nothing you can take a screenshot of. And so it's necessary to turn to the vendor and maybe get a letter, a document from the vendor saying this was enabled the entire time. So that some of these measures, especially non-percentage based measures, there may be a number of different ways that to skin the cat to find the documentation that's really going to be acceptable to the auditors. And that's one thing that is really. Let me just kind of weigh in here real quick, Brian, before we get any questions, get too deep, anything else, about best practices. There are a number of best practices, and the ones that, to me, are the most important, whether you're a hospital or a single doctor office, is that you have to have someone in charge. When that letter comes in, somebody needs to be in charge of responding immediately or very quickly to that auditor, perhaps by email, but also I would suggest arranging a phone conference, just 10 or 15-minute phone conference, just to make sure that you understand their expectations, you have access to them, and anything that will facilitate that communication. You really have to establish contact with the auditor. The worst audits I've seen are when there's a number of people involved. Everybody is scared because it's a scary thing, and so nobody really wants to own it on the provider side and take the bull by the horns. There are going to be deadlines. I know that there's a hope on the auditor side that they can resolve an audit in 90 days. I've seen them resolved much faster than that. And I've seen it dragged out much longer because there was poor communication on the practice side. You've got to look to the vendor for support. The first call I would make would be to the auditor to get communication. The second call I'd make would be to my vendor, who's probably had other users go through audits and can help supply some of that documentation. And if you were involved with one of the individual providers or small provider groups, one of the regional extension groups, that'd be my third call, because they're very familiar with helping you get to meaningful use and attest, and they can also guide you through the audit process. So those are just some of the best practices that seem to have worked pretty well moving forward. Unfortunately, a number of the appeals and audits I've been involved with, or actually appeals, is I'll be contacted by a hospital perhaps after they've already failed an audit because they didn't have best practices. Nobody would own the project. There was not clear expectation of what kind of documentation that they needed. They didn't go to their vendor for support. And so they've received a letter, a recoupment letter, demand letter, giving them 3 weeks to return a lot of money. And so then it's necessary to immediately appeal. There's every reason in the world to appeal a negative finding, but you can't just appeal and throw yourself at their mercy, hoping something will be reversed. You've got to come up with either a new reportable period or additional documentation or additional clarification. because if your initial documentation exchanges with your auditor, if they don't have everything they need, they're going to ask you for clarification. They're going to ask you for additional documentation, and they're going to be very clear about that. If it gets down to the point that you have the final determination and you fail the audit, you go to appeal level, you've got to do something new. Get somebody else involved. Just be very, very specific at that point, because you're already behind the 8 ball with the appeal folks of what additional documentation they want. There's a very common, there's a link to it on my website, the CMS appeal forms, and you can take a look at those and see the kind of information that they ask you. Part of that information is, do you want to provide any additional explanation or clarification? And you definitely want to, because what you provide so far has not been enough. So you need to come up with some more information, no doubt about that.
Well, you talked about having
more information.
You talked about having someone in charge of the audit process and really own that. It sounds like many providers, especially those who may not be as organized as they'd like to be at this point on documentation, they should put somebody in charge right now to get all that, get it as organized as they can in case they were to be audited.
You know that's really true, Brian. And for years, of course, when HIPAA first became involved, there was a hope that for every clinical practice or entity there'd be a security officer. Now, in a small practice where somebody might wear a lot of hats, it might be the head nurse or the practice manager or somebody else who's that security officer. But there has got to be somebody who was responsible during the registration and attestation for those EHR incentives. And whoever that person was, to me, is the person who would be the guardian of the documentation. Even if they leave their position, somebody else is going to be in charge, because these incentives are on a year-by-year basis. And that person probably knows more about what happened than anybody else. Frequently, when I become involved, there is a lot of fear. And the attitude when that fear sets in is that the auditors, the government's not being fair with us, they won't listen to our arguments. But all you really have to do is kind of drill down to what expectations not being met on the audit side, what particular meaningful use measure is not being passed. Very, very simply, get down to that, identify that, and look for any way that you can legitimately convince them through documentation, explanation, or some other manner that that failed measure should be reversed in your favor. Can't always do it, because sometimes people just don't do things. And if you don't have the security risk analysis, you can't pass an audit. But there is again a need to bring, especially at the appeal level, a different view, because the view that's been there hasn't worked so far, and there is no recourse after an appeal. If you don't get reversed at the appeal level, that money is going back.
So you've talked about some of the red flags that could get someone identified, but why might a provider be selected for an audit?
Yeah, I think there's a number of different reasons. One that's kind of surprised me, it may not be the most common, but I've had a few vendors contact me and say that they know that providers had claimed that they were using their certified technology to meet meaningful use during attestation, but they were not customers of theirs. I don't know if the spreadsheet's up there anymore, but CMS was providing the data on all attestations and the certified technology that each attestation, each provider had claimed. And vendors were able to download that spreadsheet, sort it, and see who had claimed meaningful use attestations with their product, and didn't recognize some of them. And so some of those people called me and said they had contacted the EHR information hotline and had reported some people. I don't know whatever came with that, but there may be some measure of that. Well, we mentioned suspicious data or spurious data, data that doesn't make sense, where the denominator is smaller than the numerator, or other reasons the data is just not matching up. I saw an attestation yesterday, meaningful use report that came out. Again, I mentioned one that was over 100%, which can't happen, and another one in which the quality measures was based not on individual providers, which it must be, but on the entire practice. So there was gigantic numbers being attested. And you really have to attest and report the numbers that come out of your certified EHR. But if I was a bettor, I would bet that some computer or somebody's going to look at that and say, these numbers are just too high. We need to take a look at these people's data. So that could be another reason. And then just the absolute random nature. Again, just spinning the wheel and seeing where it goes. I've heard anecdotal reports, I don't know how accurate they are though, that if there has been known problems with a particular EHR vendor and their ability to, where they have a lot of providers who are having trouble with audits, that maybe some people think there may be a focus to audit more of those EHRs, incentive recipients. I don't know if that's true, but I've heard some people say that. Time will tell. I have yet to see how many audits there are out there. I've asked the auditors, and they're not able to give that information. What CMS has told us is that between 5 and 10% of participants are going to be audited. The most recent information I've seen was as of March, over 160,000 unique eligible professionals and 3,800 unique hospitals have received Medicare incentives. So 5 to 10% of that group is a lot. So we know there's going to be a lot of audits. Early on in the audit process, when it was first getting geared up a year ago, I think the process, there was a learning curve as to what could really be audited by the auditors, what information they were looking for, what were going to be the problem areas, what kind of clarification to give to people who are being audited. I think that has become extremely streamlined and efficient now. And I think they can handle many more audits now than they could a year ago, just because the process has been refined so much.
So you've already talked a little bit about best practices,
Sure.
such as having someone in charge, but what are some other things that people should do?
Sure. Let me just kind of talk through the stages of an audit, because we mentioned one way to be prepared is have somebody knowledgeable who knows about the registration and the attestation process, has access to all that documentation. And if they receive an audit letter, the audit process, the first thing happens is they get that letter, and in that letter is a request for documentation. It's going to be for all documentation related to that attestation. And there may be a request for supporting documentation. An example I'll give is that if a provider claims an exclusion for some of the meaningful use measures, there may be a requirement, not always, but there might sometimes be a requirement for supporting documentation of why they were allowed to claim that exclusion. When that documentation goes back, frequently from the auditor will be their response and a request for more explanation or documentation. And this can kind of go back and forth a few times before that final determination. And that final determination is where you get the letter that says, this is the final determination, you're okay, or else you owe us a lot of money, owe the government a lot of money. And that final determination letter is not the recoupment letter. Usually about 3 weeks later, I'll see a recoupment letter come in saying to the penny exactly how much money has to go back. In that document outlines the appeal process. So it's pretty clear there. Frequently, what I've seen is the due date on the recoupment of those funds is well before you can be through the appeal process. I think, if memory serves me well, there's about the most recent one, a recoupment letter I saw for a hospital. The money was due 3 weeks after that letter, 3 or 4 weeks later. And then they had another 30 days. After that 30 days, excuse me, a 10% annual penalty was going to start be added. After 60 days, it was turned over to the Treasury Department. And so depending on the efforts and resources and the backlog at the appeal process, even if you win an appeal, you may be in a position where having to decide, well, should I go ahead and give all the money back and then take my time going through the appeal process. So that can be a little bit fuzzy.
Well, we've already gotten a number of questions from our audience, so I'm going to start to ask Jim some of those questions. And folks out there, if you have questions for Jim, please go ahead and ask them now. We'll get to as many questions as we can. If we do run out of time, we'll follow up with written answers to your questions. So let's have the first question, Jim.
Okay.
If a provider has been audited and found ineligible for S1Y1, what happens, stage 1, year 1 that is what they're saying, what happens to the subsequent year attestation? Is the following year stage 1, year 2, or does the provider have to start over?
Let's see. That's good. So the first year they would have to start over because everybody has to. No matter when you start your meaningful use ladder for Medicare, there's always 2 years at stage 1. So if you attest and it's a judge that you did not meet meaningful use stage 1, then you would still have 2 more years at stage 1. It's kind of interesting that detail around that, because even if a provider doesn't start till 2015, that year, the next year, they're going to be at stage 1, while they're going to be others at stage 2 and possibly beyond. The 2014 technology for next year, everybody has to be using it to achieve meaningful use, but you can achieve either stage 1 or stage 2 with that 2014 addition. So they'd be starting over. They'd be at stage 1, year 1 for 2 years, no matter when they started. So,
well, let's move on to another question then. What do you recommend if you met a measure's requirements for attestation in 2012, but now you don't have the documentation to prove that you did it, and the example they give is electronic exchange of information?
Right.
So they did it, but they don't have the documentation.
Right, and it's impossible to tell if they did it in 2011 and were able to provide that documentation. So if they have no documentation at all, going by the book, that won't pass an audit. However, the fact that 2013 does not require it anymore, I would see if there'd be some potential flexibility around the fact that you didn't meet it, because if you don't have the documentation, that's part of meeting it. So you didn't meet it. So I would just see if there's some flexibility around that issue. It's only going to be no flexibility around security risk analysis, because you have to have one and review it every year and modify it. But meaningful use measures that are no longer in existence, I would just see if there's any flexibility there with them, with your auditor. If not with the auditor, then on the appeal level. With the appeal level, there may be greater flexibility. The auditors have to go by the law. They have to go by the regulations. But at the appeal level, I believe there's more flexibility. So if I failed the audit, I'd definitely appeal it.
Well, here's a question that I'm sure many people have thought about. The question is, can we do a security and risk analysis now and then apply it retroactively to previous attestations? And they go on to say, we relied on the EHR provider that it had been done when we attested for 90 days. So there's often confusion about that the vendor actually does that, but that's not the case.
That's right. Yeah, CMS has a great document. It's called 10 Myths of the meaningful use security risk analysis. I think you could probably Google it and find it from CMS. And they're very clear that this is not something the vendor does. This is what the provider does. The security risk analysis has to be done it's got to be done before the end of the reporting period. It could be done before the reporting period, but it's got to be done before the end of the reporting period. And I've talked with a number of specialists who do this type of security risk assessments, and they're frequently asked, well, we know we did it, can't you just change the date? And they won't do it. However, so you cannot go back and do one retroactively. However, I would dig up any kind of documentation you possibly have. You're supposed to be doing an annual HIPAA documentation. There's probably some ongoing safety, security, privacy type meeting maybe your practice has once a year or something. I'll dig up anything that I possibly could. Whether it would meet the auditor's expectations and requirements is impossible to say, but you definitely cannot do one retroactively.
Well, go ahead.
One, yeah, to mention, because I really feel bad with so many providers out there, because again, a lot of providers misunderstood this, many vendors misunderstood this, and it's not like they were trying to do something wrong. It was a knowledge gap. And so it's a shame. Anybody who went through the meaningful use process of the Regional Extension Center should be okay, because they knew what was required and kind of made sure everybody did that. So unfortunately, now that kind of comes to another question, Brian. If you attested in 2011 and 2012, and you got money, but you now realize your attestation was erroneous, what do you do?
That's a great question.
Well, that's, I was about to say I'm not a lawyer. I sound like one when I try and get my son to take the trash out on Wednesday mornings. But what I will say is that there are forms available to correct an erroneous attestation or withdrawn attestation. I had some providers who attested in early 2013 for the last 3 months of 2012. They had a prepayment audit, and they immediately withdrew their attestation. So if you feel like you have an erroneous attestation, you can correct it. Now, again, that's a difficult place if you suddenly realize that, well, you don't have a security risk analysis. But if you have any kind of documentation at all, I would submit that, kind of like what I was talking about, HIPAA annual thing, something. Actually, the security risk analysis is a subset of the HIPAA rule that really is focused on electronic health information. So it's a lot more than just a certified EHR.
All right, let's go to another question.
That's a tough one, though. Sure.
This is a great process question. The question is, who in the organization will receive the audit letter? We have proxy status for our providers. Will the letter go to the authorized user with proxy for the provider?
Well, let me answer the first one.
Sure.
During registration, the registration process, contact information is put in, including an email address. And that's the contact that is going to go to. So if you have a practice and the office manager practice proxy, what you can do can register and attest for everybody, and it's their contact information that is in there. It would go to that contact individual. Actually, I did yesterday. A radiology group was doing 12 attestations, and in their case, it was the actual provider's email address that was put in for each one of them. So the emails are going to them, but it's whoever the contact person is during registration. During registration. If somebody moves on and those emails bounce because they're all going to somebody who no longer has that job, it doesn't take too long for the deadline passes and the auditors follow up in other ways with mail or phone calls. been tracked down who the audit's supposed to go to.
So they'll get to you one way or another.
Yeah, yeah. Mm-hmm. Yes, they will.
So here's another question. The appeal form, I'm just going to read it to you. The appeal form does look like for a 90-day
Sure.
reporting period, it looks in the appeal form like data for a different reporting period can be provided. However, CMS has indicated on webinars/teleconferences that reporting data for a different period cannot actually be used. Do you have any clarification on that?
Right. What I do know is, on the appeal form it says, because you have obviously failed to achieve that meaningful use for the period you reported because you failed to audit. So under the appeal, and I think this is an attempt of flexibility, the question is being asked, if you could meet meaningful use for another 90-day period, could you? And you can say yes or no. If you say yes, you can tell them what the other 90-day period would be. I don't believe that, and I've never had anybody go that route. We've never had to, but I would imagine they'd say, well, give us documentation on that 90-day period to see if you possibly could, because they do ask that question. Give us a 90-day period in which another one you think you can make it. So I think they're trying to be as flexible as they can. The bottom line goal of this is the introduction and spread of health information technology. And in a new program, there's going to be some misunderstandings. And so I think as an attempt to give a second chance, maybe you can meet it in another 90-day period during that year.
Here's a great question about the risk analysis. The question is the risk analysis enough, or do you have to show that you're actually mitigating the findings and have documentation of your remediation?
Yes, that is a good question. To me, the risk analysis is a living document. And so it's not something that maybe it's completed one year and then every year you take it out and initial it and date it and put it back in there. To me, a best practice of a risk analysis is that when new risks are identified, like maybe you add another location that providers are seeing patients at, or maybe you're going from wired internet to wireless internet, or something along those lines, that the document comes out, those new potential risks are added to the list, and the risk threat is identified, and if it needs to be mitigated, then it's there can either be documentation that's going to has been mitigated, or some type of plan that shows when something's going to be done. I don't believe that anybody could have a risk analysis that wouldn't identify any recommendations or things to improve on. So it's okay if it doesn't say everything's perfect right now. To me, it's that dynamic document. So I think there needs to be a mitigation plan there for when risks are identified, and there needs to be documentation of when that occurs. It doesn't have to all be fixed for the end of the reportable period. It could say, we're doing something by the first of next quarter or something like that, but there's got to be risk assessment, threat assessment, identified problems, a plan to fix those, and then documentation of the mitigation.
Well,
it's an ongoing thing.
And as an additional note, I mean, apart from meaningful use, if you've had that risk analysis and you need to do remediation, the Office for Civil Rights could also audit you, or if you had a breach, they'd look into things, and so you want to be able to show that you've actually done what you need to do to meet HIPAA regardless.
Exactly. That's so true. It's kind of fascinating to me the first time I realized that so much of this falls under the Office of Civil Rights, because this protection of our health information is considered a citizen's rights. These are our civil rights, and so it should be protected. Many practices and hospitals I've worked with, when we first start doing a security risk assessment, why do we have to do it? It's just a bunch. It's sometimes to add to. but once you start going through one, it can be really good. I mean, some true risk can be identified and mitigated. So there's some real benefit to it.
And the risk, as people have adopted these EHR systems of if you have an unsecured network or something, there's a real risk that you really could breach a bunch of records. So it's an important issue apart from just compliance.
Well, it's John, and just a little aside on that, I've asked a lot, why does somebody want to break into a system and still find out everybody who has diabetes? But that's not the real risk. The risk is identity theft. You break in, there's social numbers, there are addresses. You can, they're just the theft of individuals' identification outside of their clinical information. I think to me is the real risk.
Absolutely.
I mean, that's the value to somebody who's doing this, on a hacker mentality.
Mm-hmm. Well, here's another question for you. Our practice does not meet the requirements of some measures due to our scope of practice. Is there a way we opt out, or do we have to fill some kind of form out?
Right. There is a and I guess the reason to opt out is because under the Medicaid program, there are no penalties. Under the if you're a Medicaid eligible professional, penalties begin January 1st, 2015. They're called, I call penalties fee adjustments, 1%, 2% next year, 3%. The Secretary of HHS has the ability to change those percentages after 3%. And so there are some hardship exemptions for anesthesiologists, for radiologists. Let's see, one other group I can't quite remember now, for 3 groups. But there is a form to fill out to claim an exclusion to be exempted from those fee adjustments that start in 2015. And I believe from everything I've seen that is on a yearly basis, so it's not guaranteed forever. So there is that. Down the road, I wouldn't be a bit surprised that third-party payers start requiring at least certified technology, if not some level of meaningful use. So we'll see about that. But there is a form to claim those exemptions on a yearly basis.
Here we have, this isn't a question, this is a statement, but I'm going to read it because I think it's interesting and ask for your comments. And it really speaks to how, at a state level, the audit process, there's different contractors involved, and so it can be very different, as you were saying before. So here's the statement from this guest. She says, I've just gone through an arduous audit with a practice. Keep in mind that the auditors are learning as they do these audits. We had to explain to the auditors regarding some information about the immunization registry here in New York. So this may not be the state auditing. This could be the Medicare auditing.
Sure.
But she goes on to say they didn't understand the regulations in New York, so we supplied the documents proving our case. I find it interesting that these auditors didn't know the different programs of the state. The point is, if you believe that they don't understand some of the questions they are asking, prove your point. Don't automatically give up.
That is excellent, because it was really, the whole audit process started last summer, and so right, prove your point. You certainly want to have a good relationship with the auditors for open communication, but immunization is a great example. Some states, New York's a great example, have fantastic electronic registries. Other states, it's not electronic. It's a piece of paper that gets mailed in and then manually input into something. So that immunization is an area where there was a lot of confusion. Early on, there was a lot of confusion that 80% of patients that you saw, unique patients, had to be seen in certified EHR. And so at first, there was the belief that 80% of all your patients had to be recorded in the certified EHR. But it turned out it was just 80% of all patients that you had actually seen during the reportable period, not your old database of patients. So that's a very valid point by that listener, because those things are what, to me, as they worked out, make the whole process more efficient. Those bugs have kind of been worked out. I know the auditors, Figliosi and company, pretty much in daily, or if not more than daily, very much in touch with the CMS folks, meaningful use people, for clarification and guidance. So I know there's a lot of feedback, but back and forth between the two of them. I think the process has gotten much cleaner moving forward.
Well, we're very nearly out of time, but we've got enough time for maybe just one quick question before we wrap up. So here's our last question, and then the questions that we didn't get to, we'll follow up with written answers to those. The question is, when we attest, we use a summary report for the reporting period with the numerators and denominators. When audited, will we need to provide actual files with the actual list of patients and the numerators and denominators?
No. And that's not required. What's been required really is the meaningful use report. Stage 1 required, which we're still under, just that meaningful use generated report, how we generate a certified system with those numerators and denominators. We don't have to know exactly who those people were.
All right, well, because we have limited time, again, we're going to assemble all of the audience questions and post the answers on our site with links delivered via email later in the week. And remember that all registered attendees will receive an email with links to both the slides and the recorded version of this session. So if you missed any of it, you can come back and get all of that. I want to thank you, Jim, for joining us for today's Learning Lunch. It was a very informative session.
Brian, always good to speak with you. And this is a field that's constantly changing. And I'm sure just as the audit process was streamlined, worked out the details, the appeal process, which is just in its early stages, that process also is being refined. So look forward to coming back anytime you'd like that.
Well, we'll be sure to have you back. And for folks in the audience, if you'd like to learn more about Jim and his services through EMR Advocate, visit www.emradvocate.com. I'd like to thank all of our attendees. Again, we're going to send out an email that follows up with answers to your questions and slides from this event. For comprehensive training in meaningful use, register for Format Approved's Certified Meaningful Use Professional course. The course covers the requirements for both Stage 1 and Stage 2 of meaningful use for both eligible professionals and eligible hospitals on the Medicare and Medicaid incentive programs, along with clinical quality measures, HIPAA considerations, and more. Visit formatapproved.com/education/courses_cmup.html to register for this course. You can see that URL on your screen if that was too much of a mouthful. You can learn more about our other training offerings at formedtraining.com. Visit formatapproved.com to learn more about our upcoming Learning Lunches. The Learning Lunch button will take you to the entire slate of our upcoming webinars. Our next Learning Lunch will air August 7th and will cover the subject of Business Associate Armageddon. With the September 23rd deadline for compliance with the HIPAA Omnibus Final Rule fast approaching, our HIPAA expert Mike Simmel will tell you what you need to do right now to beat that deadline. So be sure to register for that webinar. Keep an eye on your email box on our homepage for other upcoming topics. Thank you again to everyone for joining us today.
Thank you, Brian.